The court will take on the novel legitimate address of whether a previous president can be indicted for what Trump's lawyers say were official acts taken in office, in spite of the fact that much of the center remains on whether the judges will run the show rapidly so a trial might take put before the November race. With most legitimate specialists addressing Trump's wide contention that the complete decision obstructions arraignment ought to be rejected based on insusceptibility, the court's possible administering on the degree to which official acts are ensured and how rapidly it rules will be of break even with significance. The case puts impressive scrutiny on the court, which features a 6-3 preservationist larger part that incorporates 3 judges Trump named. The court has of now given Trump an election year boost when it ruled final month that Colorado could not kick him off the vote. The judges have to come beneath feedback for their delay in taking up Trump's request, which a few see in itself as a triumph for him. The preeminent court announced February 28 that it would listen the case, saying it would look at whether and in the event that so to what degree does a previous president appreciate presidential insusceptibility from criminal arraignment for conduct affirmed to include official acts amid his residency in office. The decision immediately put the prospect of a pre-election trial in risk. A government requests court had ruled February 6 that Trump was not resistant from arraignment, composing that previous President Trump has gotten to be Citizen Trump, with all of the guards of any other criminal respondent, which whereas official benefit may have ensured him amid his presidency, it not ensured him against indictment. It would be a striking conundrum on the off chance that the president, who alone is vested with the sacred obligation to take care that the laws be reliably executed, were the sole officer able of resisting those laws with exemption. The government offers court ruled. Under the unique schedule laid out by U.S. local judge Tanya Chutkan, Trump's trial had been set to start walk 4, and the jury might have indeed come to a decision by this point. In step, the primary of the 4 criminal cases against Trump to go to trial was the arraignment brought by Manhattan area lawyer Alvin Bragg in modern York, where Trump was indicted on 34 checks of misrepresenting commerce records tied to a quiet cash installment within the lead-up to the 2016 decision. He is argued not blameworthy to all charges. The federal arraignment returned by a fantastic jury in Washington, D.C., in admirable comprised of 4 tallies. Scheme to dupe the joined together states, trick to deter an official continuing, hindrance of and endeavor to deter an official continuing, and conspiracy against rights. The Supreme Court has already listened arguments in another January 6 case that could affect 2 of the charges against Trump involving obstacle of an official continuing. Trump, concurring to the prosecution, plan to topple the genuine comes about of the 2020 presidential decision by utilizing intentionally false claims of race extortion to deter the government work by which those comes about are collected, checked, and certified. The prosecution centers on Trump's association in a conspire to yield fake election certificates to Congress within the trust that they would invalidate President Joe Biden's triumph. The chain of occasions finished within the revolt at the U.S. Capitol on January 6, 2021. Government prosecutors driven by uncommon advised Jack Smith say Trump's activities constituted arrangement of violations. Trump says he was simply communicating his concerns, which were not based on any proof, that the election was tormented with extortion. He has argued not blameworthy to the government charges. Whereas various January 6 litigants have recognized that they were duped and controlled, or that they needed the basic considering aptitudes to recognize the lies approximately the 2020 race for what they were, Trump and his attorneys have demanded that he truly accepted the election was stolen. Smith, in the interim, has contended in court papers that Trump has no resistance, which the case ought to go to trial quickly, whether or not his conduct at the time included official acts. Trump's attorneys cite, among other things, a 1982 incomparable court administering that said presidents are safe from respectful suits when the charged conduct falls inside the external edge of their official obligations. That case has never been applied in the criminal setting. A key issue, as however unresolved, is whether any of Trump's activities specified in the arraignment were official acts. Indeed, in the event that a few conduct is off limits, it would not essentially cruel that any charges are rejected.